I introduce our two speakers. We will be recording this presentation and we will be sending a recording to all attendees. We ask that you type any questions you have in the chat and we will be answering those at the end of the presentation. And we are leaving plenty of time for questions and answers at the end. And one of the interesting statistics, and for those of you that know me, I love statistics, I found recently was that positive workforce drug test reached a 20-year high in 2021. And the positive test results for marijuana in the general US workforce went up over 50% in the last 5 years. So this is actually probably a very timely presentation that we're doing for you today. I would like to introduce Phil Walls. Phil is the Chief Clinical Officer for MyMatrix, and he has been there for 16 years. What you will find with Phil, he has a wealth of historical information, a phenomenal background in clinical pharmacy, and I thought was very interesting that he was the 12th employee hired by MyMatrix. Some of you have already seen Phil present. He's a national speaker and has just a wealth of information for us. After Phil, Sue Connolly will be going. And Sue is a work comp defense attorney with over 25 years experience defending employers with on-the-job injuries. She specializes in medical marijuana cases, TBIs, occupational exposures, and very complex medical cases. So without further ado, Phil, I will turn it over to you.
Great. Thank you very much, Mary. I appreciate the introduction. Find it very interesting that you pointed out that I'm a wealth of historical information. I've been a pharmacist for over 40 years, so I guess that's where the history comes in. I'm actually joining you all today from the Omni Hotel at the World Congress Center in Atlanta, Georgia. And I'm pointing that out. I'm here attending what has been known as the National Prescription Drug Abuse and Heroin Summit. This week, they've changed the name. They officially announced that they've changed this to the National Prescription and Illicit Drug Summit. And I'm pointing that out because I find it very interesting. At this conference is the only time where I see the barriers between legal and illegal removed, and we're simply looking at drugs in terms of risk versus benefit. If a drug is dangerous, it's dangerous. Doesn't matter if it's an approved FDA drug, a prescription drug, or not. And I really like that approach. I'm here this week actually doing a presentation on stimulants. And I'm also pointing that out because that's also of significant concern outside of what's going on with cannabis. Stimulants are approaching the same crisis that we had with the opioid epidemic, but we're not hearing nearly as much about that. And what really concerns me with stimulants is there is no antidote to a stimulant overdose. Fortunately, workers' compensation, stimulants aren't causing the same concern that we have seen with other drugs of concern. But that's my topic here this week. Now, of course, for this morning, we're going to be talking about medical marijuana and its impact on your workers' compensation. Hopefully everyone is viewing my PowerPoint slides now. And again, historical information. So I'm going to take you all back to the 18th century to start things off today, before we talk about cannabis. We're going to talk about another drug, and you're going to hear me say this several times because I do not want there to be any mistakes. I'm going to talk about the plant known as foxglove, and it is absolutely unrelated to cannabis. But I have a very specific reason for bringing this up, and that is to talk about the relationship between drugs and plants. This is something that we have known about for millennia. all the most powerful drugs, in my opinion, have originated from a natural source. Foxglove just happens to be one of these. And again, it is not related to cannabis, but it could be considered a natural product. I hear that reference to cannabis quite often, is that, well, it's natural. Well, yes, it is. It's also probably covered with pesticides and everything else, but it's a natural source of a drug, just like foxglove. In the 18th century, if a patient was experiencing weakness, fatigue, shortness of breath, swelling in the extremities, and they went to their physician, he or she very likely would have prescribed that they find the plant foxglove, they use it by brewing a tea, and they would go home and they would brew the tea, and one of three things would happen. One, the tea was too weak and it wouldn't do anything at all. Two, by chance, it turned out to be just what they needed and is going to alleviate some of these symptoms. Or three, is going to kill them because the tea was too strong. And foxglove has some ingredients that can be very toxic. Okay? That was 18th century medicine. Fast forward now to the 21st century. Dropsy is now referred to as congestive heart failure. The symptoms I described remain the same. Today, even though it is considered now to be an old drug, the primary drug of treatment for congestive heart failure is digoxin. Digoxin is derived from digitalis, which is a naturally occurring glycoside in the foxglove plant. That is how we have changed. And now when a doctor prescribes digoxin, he or she is going to monitor that patient's blood level of digoxin very, very carefully, because they know that if they give the patient too much, it's going to cause serious side effects, could even cause death. But we have quality control from the FDA and the strength of the digoxin tablets. We have oversight from the physicians. We have lab tests to actually measure the results. That's 21st century medicine. When I hear discussions about cannabis today, even though I see promise in the potential for cannabis, I feel like from a clinical point of view, we've taken a 200-year plus giant step backwards in medical care. When we use a plant, there's no quality control. I mentioned the pesticides. That's already turning out to be a concern. We don't know the strength of the plant. We know there's legislation passed saying that, well, this is a low THC plant. I have not seen anyone define the quality control on how they're consistently making sure that that's the case with what is provided through a dispensary. So I have a lot of concerns about the way this has gone about. The extraction of drugs from plants is a field of pharmacy known as pharmacognosy. Pharmacognosy totally changed the medical landscape. We quit using plants. We started using manufactured drugs with quality control. Just as a historical side note, the first drug isolated from a plant was the isolation of morphine from the opium poppy, and that was back in the 19th century. So the field of pharmacognosy, although today is not very well recognized, it has pretty much been replaced by other methods, but it existed for about a century and brought a lot of very interesting drugs to the market. So let's leave foxglove, which, as I said, is not related to cannabis other than the fact that it's a natural product, and let's take a look at some other things. And you heard me very quickly switch from referring to marijuana in the title to cannabis. That is a very intentional purpose of mine. Marijuana is a uniquely American term. There are some negative connotations associated with that term. By and large, the rest of the world uses the scientific name cannabis and medical cannabis. And even though we have laws that refer to medical marijuana, my preference as a clinician is to refer to this drug as cannabis. Now, again, historical, looking at a quick timeline here, we've been aware of marijuana or cannabis being used as a medicine, as I said, for thousands of years. What I find interesting is that in 1911 is when the first state, Massachusetts, outlawed cannabis. And it wasn't too long, same century, 20th century, that California decided to legalize cannabis. So when we talk about cannabis from a medical perspective, what does it do? Well, my first concern with cannabis is that it contains more than 500 compounds. There was a point in time where we would frequently hear it referred to that marijuana or cannabis contained 420 compounds, which is where an association between the number 420 with cannabis became quite common. Today we know that it's actually well over 500. About 107 of these naturally occurring compounds are cannabinoids. Of the cannabinoids, THC, the tetrahydrocannabinol, is the main psychoactive ingredient in cannabis, whereas that's the one that can produce the euphoria, the high that someone using it recreationally or intentionally misusing it is going to experience. Cannabinoids are extremely lipid soluble, which means simply that they dissolve in fat. That is significant because that is how when a marijuana is rolled into a joint and smoked by the consumer, that is how it is absorbed through the lungs. That lipid solubility allows that absorption to occur very, very quickly. When someone is intentionally misusing a drug for the purposes of creating a high or euphoria, the faster they can get that drug into their body, the greater the euphoria it produces. Intravenous injection is the fastest way to get a drug into the system. Smoking ranks pretty close to number 2. It's a very fast way to get a drug, a lipid-soluble drug, into the body. And we're going to talk about that a little bit more in just a moment. Then there's other cannabinoids in cannabis, cannabidiol, cannabinol. And then lastly, when it comes to these compounds, we don't recognize lethal doses. That's a good thing. Doesn't mean the drug's not dangerous. It simply means that 10 years from now, even though we may be talking about a cannabis crisis, we won't be talking about the cannabis crisis in the way we have the opioid crisis, where there's the risk of death from overdose. Now, I promised Sue I was going to get through my section in about 15 minutes, so I'm going to keep going at a fairly fast pace. And Sue's going to touch on some of this as well in terms of the medicinal properties. It definitely can have an effect on nausea and vomiting associated with chemotherapy. It has muscle relaxant and anticonvulsant effects. And it is known to relieve elevated intraocular pressure in glaucoma. Now, when I hear a politician or anyone else talking about legalizing cannabis and they mention glaucoma, they lose me right there. Because the truth of the matter is, although yes, it does relieve intraocular pressure, in order to actually treat glaucoma, you have to relieve that intraocular pressure 24 hours a day, 7 days a week. For cannabis to do that, that means the senior citizen with glaucoma has to stay stoned 24 hours a day, 7 days a week, or their intraocular pressure is going to go up. So to state that as a basis for legalizing cannabis will get no support from me. The other effects, though, I think there is promise there, and I think there's even other things that cannabis can do. However, at this point in time, using the plant, whether it's smoked, consumed, whatever, there is no situation where cannabis as it exists today is superior to any FDA-approved drug that's on the market. So again, I have some concerns over some of the drivers of the legalization of this drug. Now, the human brain has what we refer to as receptors that react to THC and the other ingredients that are found in cannabis. And for those of you that can read this tiny print, what you're seeing is that throughout the brain, there are CB1 receptors. Now, these CB1 receptors, cannabinoid receptors, are activated by THC throughout the brain. In the medulla, that effect is on the area of the brain that is associated with nausea and vomiting. By blocking those receptors, we can relieve the nausea associated with chemotherapy. They have significant effects on movement, hence some of the effect as an anti-seizure drug. They have significant effects on the cerebral cortex and our higher cognitive functions. The hypothalamus, they affect appetite. Hence all of the jokes about smoking marijuana and having the munchies. And then in the hippocampus is where marijuana has an effect on learning, memory, and stress. In terms of learning and memory, there's significant impairment caused by cannabis. So when I think about cannabis in association with workers' compensation, I feel like our number one goal should be return to work, return to function. I see nothing about an impairment of learning and memory that is associated with return to work. To me, the two just do not go together. And what we see when we look at the entire human body, both the central nervous system as well as the peripheral nervous system, is that cannabis has an effect throughout the human body. This is not like, unlike opioids. I think many of you are aware of what are referred to as natural opioids, the endorphins. So endorphins are compounds produced by the human body, very similar to opioids. And so when we take opioids, whether they're from a plant source or opiates that have been manufactured by human beings, they affect the same receptors that the natural endorphins do. Same thing happens with cannabinoids. The human body has an endocannabinoid system that is prepared to react to these drugs. This all occurs through what is referred to as receptor theory. It is a theory because we can't physically see the interaction of a drug and the surface of a cell, but we've done enough tests and enough experimentation that we know that an interaction does occur at that level with any drug. The drug interacts with that receptor very much like a lock and key. This is not unique to cannabinoids. And the drug either unlocks a reaction or locks a reaction, depending on whether it's stimulating that receptor or blocking that receptor. So with the cannabinoids, the first ones, the CB1 receptors, primarily located within the brain and the central nervous system, very much react with tetrahydrocannabinol, the THC. Then some of the other ones, some of the cannabinols, react with CB2 receptors, which are located throughout the periphery, have different effects than what the CB1 receptors have. And then there's cannabidiol. Cannabidiol being associated with studies on seizure activity and things of this nature, don't directly fit either of those receptors. It sort of falls somewhere in between the two. And the interesting thing about cannabidiol is that it can produce its effects without producing the euphoria or the memory or the learning impairment that the THC can cause. So this is where we now get into 21st century medicine. Rather than using a plant, let's understand the promise that these ingredients, these compounds that occur in this plant can produce. And now let's do what pharmacology has been doing for decades, which is to isolate different aspects of a drug and then to take that to a level where we can maximize that potential. That's the real promise of studying these drugs. Now, there are some concerns with this, and then I'm going to turn it over to Sue to look at some of the legal aspects. But when I think of cannabis, I have to point out, first of all, that about 1 in 10 people that use it on a regular basis will become addicted. Now, in all fairness, this addiction is not the same as addiction to something like methamphetamine or any of the opioids. I've heard it described as being more akin to the addiction that a cigarette smoker would experience. So if someone becomes addicted to cannabis and they give it up, the withdrawal is very similar to what a cigarette smoker would go through. Nonetheless, it is an addictive substance. The poisoning risk rises with the THC content of the plant. Now, I said we don't have to worry about death or overdose, and to my knowledge in medical science, that is a true statement. However, there is poisoning associated with high THC content. And what we're seeing, and I'm going to pick on Colorado for a moment because they were one of the early states to legalize it for medical and recreational use. The cannabis being grown in Colorado has a very high THC content, much higher than what many users of cannabis have experienced in the past. Why is this? Well, there's a variety of reasons, but not least of which, in the past, in all 50 states, cannabis was illegal to grow it. It was a clandestine operation. It was difficult for the farmer to tend to his crop, so to speak. And so the plants suffered. Now that it's legal, they can be grown openly. They can be fertilized. We can treat them for with pesticide. We can make sure they receive plenty of water, and they are a very water-thirsty crop. And as a result, the plants are healthier. The THC content is going up. Now, in terms of poisoning, ask an emergency room physician in Colorado what he or she thinks about legalization of marijuana, and they'll tell you, well, all the folks going there for their marijuana vacations all too often are ending up in the emergency room with projectile vomiting, because that's one of the signs of poisoning, and in some patients, even a psychotic break. So it is not the safe drug that we sometimes hear it referred to. As I mentioned earlier, it affects the brain in terms of memory, learning, attention, decision-making. Long-term, heart attack, stroke, lung health, all the things that we traditionally associate with cigarette smoking, we should apply to cannabis. Now, I've heard people say, well, the cancer risk is not as great. I think a better way of saying it is the cancer risk is uncertain. In the past, again, as an illegal drug, we did not see regular frequent use as often as we are today. As we see more frequent use, especially being smoked, I'm afraid the cancer risk is going to increase proportionally. And then lastly, use among teens and children is very concerning to me. This is something that as it's becoming legalized, we're starting to see an increase in this area. Now I'm going to turn it over to Sue, and then I'll rejoin everyone in a little while when we do the questions and answers. So Sue, thank you very much.
Thanks, Phil. Where were you when I was trying my beer bot case? Just excellent information. You can go ahead and move the slide forward. I'm going to talk about some of the legal aspects of what's going on with marijuana across the country. As Phil indicated and Mary has indicated, across the country, and I think as everybody knows, more and more states are authorizing the use either recreationally or medically. 18 now have passed recreational use, plus the District of Columbia and Guam. 37 states have passed medical marijuana in the District of Columbia, Guam, Puerto Rico, the Northern Mariana Islands, and the US Virgin Islands have also approved medical marijuana, and that's updated as of April of this year. 13 states permit CBD oil with low levels of THC. Go ahead, Phil. So that's where we stand with regard to where we are as a nation with regard to marijuana or cannabis, as Phil likes to correct me when I use marijuana, but that's kind of the term of art that I use. And we can switch to the next slide. Basically, what I've done is I've used Minnesota, but basically what every state uses when you're dealing with workers' compensation is you have to have some type of a qualifying condition which would certify the use of medical marijuana by a treating physician. And basically in Minnesota, in workers' compensation, it's either intractable pain or chronic pain that are typically the precursors for what was allowed to be used and to qualify the condition. You can use it. There are certainly, you can move forward, Phil. You can go forward with the next one, and you can go forward, please. And it just basically, that's what you're looking for, is what is the qualifying condition which would authorize the use. Now in Minnesota, as maybe many of you know, it has been, it is now illegal under Minnesota law, but just to give you a backdrop, I think states that are still allowing it and allowing for it, it is the qualifying condition that would be the precursor that's certified by the physician. You can go forward. Now in Minnesota, Governor Tim Walz signed a law that as of March 1st of this year, it allows for smokable marijuana. And the reason they did it in Minnesota is because it is so expensive here, or it was so expensive, and they were trying to cut cost with smokable marijuana. Because of the Bierbach and the Musta cases here in Minnesota, we have not seen or been able to see how this is going to play out. But I think, as Phil has indicated, it certainly is going to create more problems for comp and for employers if the US Supreme Court hears the case or cases and allows it to move forward. So we will see. But right now, it is still a work in progress here in Minnesota. Go ahead. And you can go forward. Basically in Minnesota, and I believe it would be true throughout most of the country, the doctor can certify the usage of medical marijuana, but there cannot be a prescription by a doctor. And that it doesn't matter if it's Minnesota or across the country. Under the Controlled Substance Act, it's illegal for a doctor to prescribe medical marijuana. So the way states have gotten around it is the condition is certified. In Minnesota, the employee then goes to the Minnesota Department of Health, files an application, pays a fee, and then takes the card to a dispensary. Across the country, there's different ways of doing it, but basically the employee gets certified from a doctor and then goes to a dispensary for the concoction. Go ahead. So where are we across the country with regard to the law, and as the law is moving forward? You can go forward, Phil. Basically, under the Controlled Substance Act, what does preemption mean? Preemption means that there is a conflict between state law and federal law. And when there is a conflict between those two laws that you cannot consistently stand together, state law is preempted. You can move forward. So you can go forward. What we have then is, under federal law, medical marijuana or marijuana of any nature is illegal. Under state law, we have states allowing for recreational use and medical use, but that is inconsistent with federal law, and that is where the federal law preempts the state law, and that's the arguments being made in various states. Now, what happened is that there are riders. There's a rider that's attached to the appropriations bill every year, wherein in that rider, the Department of Justice cannot use funds, the Department of Justice can't use funds to go after any party in a state that complies with state law. So in other words, they can't use any funds under the appropriations bill. Those riders, that's been going forward since 2014. There were policy memos that started in 2011, the Ogden memo, and then the Cole memos in 2013. There were two of them that basically said if you comply with state law and that you're not going on federal grounds and you're not, distributing to minors or crossing state lines, as long as you're compliant with state law, we're going to leave you alone and not use Department of Justice funds to go after you. What happened under the Trump administration on January 4th, 2018, the Sessions memo came out and said, we're going back to the way it was before the Ogden memos. And basically, we're going back to the prosecutorial principles to tackle the growing drug crisis. So in other words, they pretty much obliterated the Ogden and Cole memo. Trump, during one of his one of his statements, he said, I could issue an executive order that disallows, medical marijuana or marijuana. and that basically the appropriations bill or the rider does not apply. Now, then you get into executive branch and legislative branch, because the legislative branch has the purse strings. Trump never did it, but he threatened that he could do it. So what we have now is we have a lot of states moving forward with marijuana recreationally and medically, but we have the federal government that's at attention of they basically, in terms of what's going on there and and there's conflict and there's tension. So nobody knows what the federal government wants us to do, because Biden has not come out with any kind of a policy can move forward. So go forward. So where are we with case law? New Mexico basically was one of the first cases in 2014 with Colorado that allowed for reimbursement of medical marijuana in workers' compensation. Go forward. They were one of the first, and we know that Colorado did. There's also the Dish Network case. That's an employment law case, however, that the employee was allowed to be fired, even though he had medically, not prescribed, but certified marijuana for his ALS or for a paraplegic. He had a pretty severe condition, but he was allowed to be fired because there was marijuana in his system. The case that really has prompted case law that is moving forward was the Burgoyne case in Maine. And basically the Supreme Court said, look, if you reimburse medical marijuana, you could be convicted under federal law of aiding and abetting a federal crime. So they said, and they held, that the CSA preempts ordering an adjuster or an employer to reimburse for medical marijuana. So that was the Burgoyne case. So cases following Burgoyne kind of followed the pattern of what they were doing. And this was in 2018. Go forward, please. Two other Supreme Courts, however, across the country reached a different conclusion. Panagio, which is a New Hampshire case that came out in March of 2021, said, nope, we're reaching a different conclusion from Burgoyne. The adjusters or the employers are not aiding and abetting a crime. And Hager, which was a New Jersey case in 2021, basically reached a similar conclusion to Panagio. So what we have is we have the Burgoyne case in Maine, we have the Hager case and the Panagio cases, which are at opposite ends of each other in reaching conclusions. So we have a difference of opinions from the various Supreme Courts. Now, what we have are two cases out of Minnesota. One is the Bierbach case, and the other one is the Musta case. And what happened in those is with the Musta case, that's a sanitized version. The facts were stipulated. The employee, the parties agreed that medical marijuana was reasonable and necessary. However, their position, it was preempted under federal law. So they proceeded up the channel to the Minnesota Supreme Court. The Bierbach versus Diggers Polaris, that was my case. I tried it. It was a full evidentiary hearing. We did not stipulate to reasonableness and necessity. In fact, we argued, one, that the state law of Minnesota was preempted by federal law under the Constitution. And we argued that the medical marijuana was not reasonable and necessary for many factors, including the fact that the employee had a substance abuse problem. And during the course of over 10 months, his increase of medical marijuana had increased over 5 times, more than that. I mean, it had just gone exponentially, and he would have had more, except it was too costly. You can go forward. So the Controlled Substance Act is what I said at the beginning here, is that it's unlawful for a person to possess an illegal substance or a controlled substance. Marijuana is a controlled substance. And that was the basis of our argument under under the Controlled Substance Act and under the Supremacy Clause of the Constitution. I won't get into the details and bore you with it. I could go on forever about it, but I don't want you to be falling asleep here. So the next slide, please. But that's basically was the arguments that we made. So what happened then is that I can talk to you about Bierbach. I lost Bierbach at the lower court. The court obviously said they had no jurisdiction, the compensation judge, no jurisdiction on preemption, which he didn't. And he also took the position that the marijuana was reasonable and necessary. We then went up to the Workers' Compensation Court of Appeals. That's the next level in Minnesota. And the Workers' Compensation Court of Appeals, in short, affirmed the compensation judge. We then appealed to the Minnesota Supreme Court, both on preemption and on the lack of reasonableness, and it was not reasonable and necessary. MUSTA was following track. They were doing the same, only on the issue of preemption. So we were going up on the same track up to the Minnesota Supreme Court. What's interesting is that the Supreme Court heard oral argument on both cases on the same day. We were first in line, but they switched it and then took MUSTA. And I think MUSTA was the easier case to look at because of ours was a fully developed record. They then held and agreed, similar to Burgoyne, that it was aiding and abetting, and they reversed the decision of the Court of Appeals. So in other words, we won. What's happened now since then is that the employees in both MUSTA and Bierbach have filed what's called a petition for writ of certiorari to the United States Supreme Court. They are asking the Supreme Court to review both of these cases. That's in essence what's happened. Just a little bit of detail here, because it's interesting, at least to me, is that they've, how do I say this? The MUSTA case went up very quickly. They filed the petition very quickly. In our case, they held back in filing the petition until they had to. And that we believe that is because we believe the parties kind of got together and they want the Supreme Court to review MUSTA and not us. Because if they review us, they're going to see all the problems associated with medical marijuana. And with MUSTA, they only have, it was reasonable, they felt it was reasonable and necessary. It's just the preemption issue. So that's kind of where we're at. So we did kind of an end around, and we got it so that our opposition to the petition was filed. We had to really file it quickly. We filed it quickly so that the Supreme Court in conference, when they conference these cases in chambers, they would have both of them at the same time, so that MUSTA wouldn't come out first before us. So on February 22nd, 2022, the Supreme Court then issued its order, but instead of saying that they were accepting certiorari or not, they asked the Solicitor General of the United States. This is very rare. I mean, very rare that this happens. They asked them to issue a brief on their position on what the Supreme Court should do. So what happened after that is we sent a memo to we actually we retained SCOTUS counsel in DC because frankly that was a little bit above my pay grade. I'd not done that before, and I'd certainly never contacted the Solicitor General. So we together wrote the memo to the Solicitor General and said, this is the position we believe you should take. The Solicitor General then contacted us for a conference call, all the parties. And what happened is all the parties in the case, which are 4, had a separate conference call with the Solicitor General. Ours was on March 17th. The offices of the Solicitor General, the Attorney General, the Department of Justice, the Department of Human Services. There were more agencies and alphabet agencies than I can probably count on my hand that were in attendance that day with various attorneys, a lot of lawyers, Even there was an attorney there for money laundering that were there that are very interested in these cases. And basically, our SCOTUS counsel took the lead, and then the Solicitor General basically asked all the questions and then started asking questions about Minnesota law and the case. And then I actually ended up, I didn't think I was going to have to be talking very much, and ended up spending a lot of time talking to them about Minnesota law and the Bierbach case. They have not contacted us since then, excuse me, and we expect their decision or their brief in May in terms of what they're going to recommend the Supreme Court to do. What I think that they're going to do is recommend, if they recommend the Supreme Court hear the case, that they'll recommend Musta, because that's the easiest case for the Supremes to go to hear. So that's where I think that's at. You can move forward. How am I doing on time, Mary? Okay. What's interesting in terms of cert, there was a case in June of 2021, and it was the tax code to allow business to deduct business expenses, and this was for for marijuana. But because it was prohibited by federal law, they said it was an equal protection, that they're a business, they should be able to do it. But because it's illegal under federal law, the court didn't hear it. They denied the petition for writ was denied. So from our perspective, we're thinking, well, look, they denied that petition. They ought to deny our petitions and let the law stand in Minnesota, which they could do. We don't know. But that's kind of, I thought that was just a little bit of an interesting piece here that happened. And Justice Thomas was the one that wrote the decision. Next one. So what do you do for those of you that are still dealing with this here in Minnesota? We're kind of all the cases now are just on hold. Nothing is moving forward because it's now illegal. The standard is reasonableness and necessity. We have treatment parameters in Minnesota, but they can't apply, in my opinion, in Minnesota, they don't apply. That was not what the comp judge said, but it doesn't apply to marijuana. It applies to opioids and other types of medical treatment. So go ahead, you can move forward. So what you are looking at typically in most of your cases is reasonableness and necessity of the medical marijuana. So what you want to do when you're investigating, whether you're an employer or whether you're an insurer, is you want to document the frequency of use, the amount of use, the increase of use, the duration of use. You want to consider a deposition of the registered pharmacist. You may want to get Mr. Walls involved to actually look at this and render an opinion on this. You want to consider a deposition of the treating doctor. You want to maybe consider a pain specialist. I still think that considering a pharmacist to go over and help you sort through what the employee is taking and what he is doing or she is doing might be helpful. As in our case, the increase of usage. And is there any testing, or what suggestions does Mr. Walls have? Go forward. And I can tell you, other than yesterday, this is the first time I met Mr. Walls, and I'm serious when I'm saying, had I known about Mr. Walls, I would have retained him in our case to look at it, our records, and to look at the Leafline records. I mean, they're giving these concoctions. I have no idea what they are, what's in them. And so you want to, find out what are in these concoctions, how much THC is in them, and is it affecting this person's mental acuity, their memory, their attention? Is it impacting their ability to work? Is it impacting their ability to do their job? So legal department and claims should work together to develop an overall strategy. That is critical. When I did the Bierbach case, I can tell you that United Fire Group and I were in lockstep. We agreed from the get-go that this case was going up. This had a perfect fact situation with a guy with substance abuse, and we were going up. And it was pretty much earmarked to go to trial and to go up to the Minnesota Supreme Court. You want to look at past chemical dependency usage. In our case, he had a past chemical dependency and he was treated for substance abuse within a year of applying for marijuana. So was, from our perspective, very important. Were there past DUIs? Our guy had a DUI within, and that's why he had to be hospitalized for substance abuse. So you want to get the medical records from whatever the dispensary is that the employee has chosen to go to. You want those records to see what is in them, what the concoction is, or what they call the concoction, who the registered pharmacist is, and if there's any history of any illicit use or other use or substance use. You want to know all those factors. So in Minnesota, it's Leaf Lines and Minnesota Medical Solutions. I don't know all the dispensaries in your various states, but that's what you're looking for. You want to get those records. I did try to get the records from the Department of Health. I was not successful. If I did it again, I would subpoena them to see what is in those records. Go forward. So what are the future issues that we're looking at? And, you know, for Minnesota, it's smokable marijuana. Some of you may be dealing with it already, but it's what are the amounts of THC? What are the employees getting? And the ability to test. And that's something, you know, I would ask and talk to Mr. Walls about. Okay, what do you think about this? What are your thoughts on this? What is the impact on the employee, on this specific employee? And that's all I have. Thank you very much for the opportunity to speak with you today.
Thank you, Sue, and we will open it up for questions. But Phil, while we check out all the questions, Sue actually asked you several questions. I don't know if you have any comments from all the things she threw at you.
Actually, I do. Thank you for the opportunity, Mary. One thing that I actually learned at the summit here in Atlanta this week, there are over 300 documented drug interactions between prescription drugs and cannabis. Now, we have created a data void in the way the states have gone about legalization rather than a federal legalization. The data void, two that I'm going to refer to, the first one has to do with a pharmacist's ability to check drug interactions. Drug interactions are primarily based on prescription drugs. Cannabis is not a prescription drug. It does not exist in those databases. Now, my pharmacists have found workarounds, and so they're able to identify those interactions, but we don't need workarounds. We need systematic approaches that allow pharmacists throughout this nation's pharmacies that are dispensing over 4 billion prescriptions a year to very quickly determine if there is an interaction with the patient that's receiving cannabis. That doesn't exist today. So that is very, very significant. The other void we've created is in our state prescription drug monitoring databases. Again, keyword there is they are prescription drug monitoring databases. So cannabis is not reported, with rare exceptions. The only thing that comes to mind right now is the state of Connecticut, where they tied their card program, for lack of a better word. In other words, those patients that are eligible to receive medical marijuana are listed in their state database. So at least the prescriber knows if that person is eligible to receive cannabis or not. Going back to those drug interactions, another important fact for workers' compensation is the primary drugs that cause interactions read like a litany of the top 5 drug categories in workers' compensation. Opioids, benzodiazepines, skeletal muscle relaxants, antidepressants, sedative sleep hypnotics. So all the drugs our patients are seeing have significant drug interactions with cannabis. So those are the takeaways I took out of that.
All right, we have a couple of questions here. Gloria is asking, do qualifying conditions change by state? What is the best way to access qualifications by states? And Phil or Sue, who would like to go first?
I can.
Sue, all right.
Yeah, the qualifying conditions will change by state. We have a cheat sheet that we've sent to Mary that if you're looking for, but basically it's the case law. I think what you have to do is you need to know what your marijuana statute is in the state And within that statute, the qualifying conditions I would assume would be listed.
Okay. And the next question is coming from, in a previous life, I was a 911 dispatcher communications officer in Arizona. The LE community was beginning to flirt with the idea of establishing a mathematical formula to set limitations on the amount of marijuana in the bloodstream to establish legal guidelines for DUI laws. Are there any medical standards working on this now for work comp laws? That's a great question. Go ahead, Sue.
Not to my knowledge. We were talking about this yesterday, and I was telling Mr. Walls and Mary and Alan that Stanford was looking at what's called a potalyzer several years ago to help with determining the level of marijuana or THC in somebody's system. But when I've attempted to look for it or try to find it, I have not been able to do so. There are some states that do have some blood tests, and they indicate that if it's like for purposes of DUI, if it's a 5 nanogram or 6 nanogram, they do have that. But I can tell you in Minnesota, we don't have anything yet. There is nothing that's really consistent that I have seen across the United States. And I'm not aware of anything in work comp, and maybe Phil is, but I'm not.
No, not aware of anything. What I would add to that is it is going to be difficult to establish a blood level. Doesn't mean we shouldn't try, but my understanding clinically is that a habitual user can have a relatively high blood level and not be significantly impaired. Keyword there, significant, however that's defined. Whereas a new user of cannabis can have a relatively low level of cannabis or THC and yet be significantly impaired. So unlike alcohol, I think we're going to have a hard time saying what that level should be.
Yeah, I agree with Phil on that, like what's happening is before we had the breathalyzers, et cetera, for alcohol, officers would, you'd walk the line and you'd do the nose. And I think some of them are doing that with regard to marijuana to see if they are impaired or not, because Phil's right. The marijuana can stay in your system for a number of days and it doesn't mean you're impaired. So it is a problem.
Well, wonderful. Well, that's the questions for now. Of course, I have several for you that I will send you both. As we advised, we have recorded this and you'll all be receiving a copy of the recording. And then if anyone would like Sue's cheat sheet of the different laws in the United States, please let us know. And we're happy to share that with you as well. And you will have Phil and Sue's contact information in the presentation. And as you've seen, they really are experts. We're glad you're on our side because that is very concerning. How do we have people in safety sensitive positions if it's legal in some states or if they come and all of a sudden have the medical marijuana, because it doesn't sound like it's really well regulated. So I want to thank you both so much and thank everyone that was able to attend, and stay tuned for our next webinar. Thank you.
Thank you.